Good morning, everyone. My name is David Picking. I'm one of the senior workplace relations consultants at the Victorian Chamber of Commerce and Industry. Just before we start, I'd like to firstly take the opportunity to acknowledge the traditional owners of the land on which we meet today. And of course, for many of us, they're different places, given that we're delivering this webinar to you remotely. So wherever you're joining us from, I'd like to acknowledge the traditional owners in your area. For me, that's the Wurundjeri people. I'd like to also pay my respects to their elders past, present and emerging. This webinar is being recorded and will be available to view again via our website. So if you want to have a look again or recommend it to someone else, just go to our victorianchamber.com.au site and search for non-member IR support. So today we're providing an overview of the unfair dismissal and general protections jurisdictions of the under the Fair Work Act 2009. This is our third in a series of non-member webinars, and the previous webinars have been around Fair Work, Small Business Fair Work Dismissal Code and the redundancy process. So we encourage you to have a look at those as well. In our experience, employees tend to have a pretty good understanding of their rights. Even if they don't, it's very easy to find information online or from numerous law firms that deal with employment matters. So traditionally, it's been assumed that employers have a relatively greater power or influence in the employment relationship. So the objective of the unfair dismissal protections under the Fair Work Act is to provide a fair go all round. Employees also have access to the general protections option if they think their workplace issue or dismissal is unlawful as opposed to unfair. This option is often referred to as adverse action, so you might have heard it called that. And that's because the claim would be for a remedy of an adverse action or a decision which results from breaching one of the protections that we'll talk about today. Both of these jurisdictions are areas of significant activity, and the Fair Work Commission is well and truly open for business. During the 2018-2019 financial year, the Fair Work Commission received almost 14,000 applications for an unfair dismissal remedy and around 5,500 general protections applications. Most of those involved dismissal as well. So together, unfair dismissals and general protections represented more than 60% of the applications made to the Fair Work Commission in the last financial year. We hope you never have to deal with one of these claims, but we want to provide you with a little bit of advanced understanding of how these claims work so that you're in a good position to defend one. But we think one of the main reasons why we see so many of these claims is that it's a low-cost jurisdiction. An applicant doesn't have to be represented. They may use a no-win, no-fee lawyer, or they may represent themselves, and it only costs around $70 to lodge an application. Most matters are resolved at conciliation, and many with a monetary settlement of $8,000 or less. So by filling out an application and attending a 90-minute conciliation conference, the applicant may be able to obtain some compensation for little or no cost to them. So you can see why we received a lot of these. We obviously want to put you in a good position to respond to a claim if one arises. So I'll give you a few tips today on how to prepare. These processes are quite complex and can be quite challenging to respond to. We'll only be able to provide an overview to you today, but we recommend you seek advice on any specific unfair dismissal or general protection matters. And I mentioned also that we've provided some related information on previous webinars, so please have a look at those. So just a quick disclaimer, we've taken all efforts to make sure that this information is accurate today, but as I mentioned, if you have specific queries about a specific case, we always recommend you get advice or assistance from someone who has the expertise in this area. So what will we be covering? We'll talk about what an unfair dismissal is. We'll talk about the definition of general protections, or adverse action as some call it. We'll look at a comparison between the two jurisdictions. There are some overlaps. And we'll look at some of the common pitfalls and how you can be better prepared to defend a claim or respond to a claim. So let's turn first to unfair dismissal. As I mentioned in my opening, they're the most common Fair Work Commission matter you're likely to face. They're certainly more common than general protections matters, and they tend to be a little less complex than general protections matters as well. So the objective of the unfair dismissal jurisdiction under the Fair Work Act is to provide that fair go all round. So the Act is designed to provide a framework for dealing with unfair dismissal, and it's meant to balance the needs of business, including small businesses, with the needs of employees. It's also intended to be relatively informal. So the process is designed to be quick, flexible, and address the needs of employers and employees, as I mentioned, and to provide remedies for if a dismissal is found to be unfair. And there's an emphasis on reinstatement, which obviously is quite significant for employers. That can be quite tricky to manage if someone is reinstated. So of course, to be protected by unfair dismissal laws, there has to be an actual dismissal. It might seem obvious, but sometimes that takes a little bit of unravelling. So Section 386 of the Fair Work Act defines when a person has been dismissed, and it states that the person's employment with his or her employer has been terminated on the employer's initiative. So the employer has taken the active decision to sack the employee. Dismissal also occurs if the person has resigned from his or her employment, but was forced to do so because of conduct or a course of conduct engaged in by his or her employer. So here we're talking about things like constructive dismissal or resigning in the heat of the moment, where someone feels that they didn't have an option but to leave their job. A dismissal does not include where someone's demoted in their employment without a significant reduction in duties or remuneration, and where they remain employed with the employer. Dismissal also does not include where a contract ends because it's been put in place for a specific period of time, a specified task, or for the duration of a specific season. There are some complexities to that, and it's arguable sometimes whether the employer has actually ended that contract. We won't go into that today, but it's worth being aware of it. It's also not possible to make an unfair dismissal claim if you had a training arrangement like an apprenticeship or a traineeship, and that came to an end as a result of that training period concluding. All right, so what is unfair dismissal? So we've established what a dismissal is, and so obviously there needs to be a dismissal for an unfair dismissal matter to occur. Once we've established whether or not there was a dismissal, the Commission then looks at whether or not that dismissal was harsh, unjust, or unreasonable. And no doubt you've heard these terms. Typically, when we're talking about unjust, we're talking about if someone was dismissed for perhaps something we don't have evidence to show that they did or didn't do. So if we've conducted an investigation, but perhaps the evidence isn't sufficient to confirm that dismissal was warranted. The unreasonable element typically refers to the process followed. So if we haven't followed a fair process, and harsh tends to deal with the impact on the person of being dismissed from their employment. And we'll talk a little bit about these concepts a little later on. If the dismissal was consistent with the Small Business Fair Dismissal Code, then it won't be something that someone can seek protection under the unfair dismissal rules from. So to put it another way, a dismissal is not unfair if the dismissal was consistent with that Small Business Fair Dismissal Code. And as I mentioned, there's a previous webinar you can go and view which deals with that in more detail. Okay. The other absolute defence to an unfair dismissal claim is where there was a genuine redundancy. So if it's not a genuine redundancy, then a person may apply for those unfair dismissal protections. And again, we've dealt with redundancy in a previous webinar, so I won't go into a lot of detail on that. Suffice to say that for a redundancy to be considered genuine, or to put it another way, if a redundancy is not genuine, What that means is that the employer still needs the employee's job performed by someone. So there's actually been no redundant job identified. A redundancy is not genuine if the employer hasn't complied with any of the applicable consultation obligations under an award or an enterprise agreement. So really important to make sure you cover off on that. And a redundancy is not genuine if you could have reasonably given the employee another job, if you could have redeployed them. So who can access these protections? They're quite good protections, the unfair dismissal protections, but there are limits to who can apply. There's a time limit for a start. So you must apply within 21 days of the dismissal taking effect, and the application goes to the Fair Work Commission. There's also a minimum employment period. So you must have been employed continuously in the role for at least 1 year for a small business or 6 months for all the other employees. And there has to be one or more of the following apply. You have to earn less than the high income threshold, that's currently 153,600, or be covered by a modern award, or be covered by an enterprise agreement. So one of those three things has to apply. Okay, let's turn now to general protections and give you a brief overview of general protections. So this is actually quite a complex part of the Fair Work Act. The general protections are very broad ranging. You recall we talked about unfair dismissal being, fairly tightly contained to a few different scenarios. The main intention of the general protections part of the Fair Work Act is to protect employees, prospective employees, so people who are applying for employment, and to protect employers from adverse action due to unlawful, discriminatory, or victimising behaviour. So general protections matters may involve claims with or without dismissal. So the claim might not relate to termination of employment, but often they do. The majority of the cases do, and so we'll spend most of our time today talking about those. So as I mentioned before, sometimes people talk about this jurisdiction as the adverse actions jurisdiction. And this is because the Fair Work Commission needs to be persuaded that an adverse action has occurred as a result of an unlawful or discriminatory reason. The general protections objectives are to protect a number of things. So the main protection is to protect workplace rights. And this is the area where in our experience, we see the most common general protections claims. And we will talk about what a workplace right is in a moment. But typically a workplace right is where you have access to a benefit for under a workplace law, so health and safety legislation or the Fair Work Act. You've got access to a benefit under an award or an enterprise agreement, like penalty rates or overtime or working hours, that kind of thing. If you've made an inquiry about that workplace right, or you have accessed that workplace right, taking leave, those kinds of things, you're protected from any adverse action as a result of exercising that right. You also have a workplace right to make complaints about workplace issues, and it may be that you might experience adverse action because it was assumed or predicted that you might make a complaint. General protections also deal with freedom of association, which is very generally your freedom to be a member of a union or not a member of a union, your freedom to be represented or not represented by a union, and your freedom to engage in or not engage in union or industrial activities. Further, the general protections cover discrimination. And again, this is an area where we see quite a bit of activity. It's quite similar to discrimination protections under other laws. The difference being here that the protection is actually against the adverse action, which is motivated by one of the attributes. And the attributes we're talking about are similar to what you'd see in discrimination legislation. So race, colour, sex, gender, age, and so on. The Fair Work Act has a couple of different attributes, and certainly if you were facing a general protections claim in relation to discrimination, again, we'd strongly recommend you get some advice. And finally, the protections talk about relief. So the compensation or other relief from someone who's experienced an adverse action as a result of discrimination, victimisation, or another unlawful behaviour, usually by an employer towards an employee. But the protections are quite broad, as I said before, and even cover protections for unions, union officials, contractors, and people who engage contractors. Most importantly for us though, typically we're talking about an adverse action by an employer against an employee. So what is an adverse action? It can be a whole range of things. Section 342 of the Fair Work Act attempts to define it for us. Clearly, an adverse action is when we dismiss someone. An adverse action might also include injuring the employee in his or her employment. And I just want to explain that a little bit, because injuring an employee is not a physical injury or a psychological injury. What it's talking about is where the person's financial or legal position is worsened by an action by the employer. Item C on this slide, an adverse action might be where we alter the position of the employee to the employee's prejudice. Again, it sounds a little bit legalistic, but what we're talking about here is where we might have affected the person's employment in a way that's perhaps legally undermined their employment. And it has been argued in case law that things like issuing a warning alter the person's employment to their prejudice. And of course, an adverse action could be where we discriminate between the employee and other employees of the employer. So where we've discriminated on the basis of a protected attribute as per the this, or similar to discrimination law. Very quickly, I just want to cover off on a couple of other protections. Sham arrangements. So if we've set up an employment relationship which is set up as an independent contractor arrangement, whereas it should really have been an employee-employer arrangement under a typical contract of employment, then there are protections against that in the Fair Work Act. The general protections, I guess, are dealing with a situation where we might be trying to avoid employment entitlements by setting up that contractor arrangement. And similarly, there are some less common protections that we deal with under general protections. This is where an adverse action might have occurred in terms of coercion by the employer, usually towards an employee, undue influence or pressure or misrepresentation. I won't spend a lot of time on these issues because they tend to be less common, as I said, but certainly get advice if this is presented to you in a claim. So how do the two jurisdictions compare? One of the key similarities, of course, is that unfair dismissals and general protections most often relate to dismissals. Another similarity is that they both jurisdictions tend to be dealt with in the first stage in an informal conciliation conference with the Fair Work Commission. Conciliation conference is usually coordinated by a conciliator, sounds logical, but sometimes commissioners get involved in those conciliations as well. So let's look at a few other similarities or comparisons between the two. So for unfair dismissal, there must be a dismissal involved. General protections may or may not involve a dismissal, but often do. Unfair dismissal, employees only are protected. So this excludes independent contractors, excludes labour hire workers or people who are employed through a recruitment agency. And in most states, the public sector is excluded. In Victoria, though, those powers were referred to the Commonwealth many years ago, so public sector typically is included in Victoria. Under general protections, the protection is extremely broad. So includes public sector, also includes contractors, unions, employers are protected also. Unfair dismissal. It requires a minimum employment period. Remember I talked about 6 months or 12 months, depending on whether you're a small business or not. Under general protections, there's no minimum employment period required. So this is where we often see a dismissal type action that doesn't qualify for that minimum employment period for someone to make an unfair dismissal application, and perhaps moves into the general protections arena, and people will be looking at whether or not a workplace right was breached, or perhaps a discrimination issue, something like that. For unfair dismissal, the person's salary must be within a certain limit, or they must be covered by a modern award, or they must be covered by an enterprise agreement. General protections, there's no salary limit, and there's no requirement to be award or agreement covered. So clearly, it's a much broader jurisdiction. Let's talk a little bit about onus of proof. So in an unfair dismissal matter, the onus of proof is on each party. So, for example, if I'm making a claim as an applicant, I've got to prove that the dismissal was unfair. I've got to provide some evidence. If it's claimed that the dismissal was due to perhaps a misconduct issue, then the respondent, the employer, needs to provide evidence of that process that led to that decision. So there's effectively a shared onus of proof. In general protections, there's a reverse onus of proof, and this is quite significant because it means that whatever the applicant says is the reason for dismissal, for example, that will be accepted as the reason unless, as an employer, I can provide evidence that the dismissal was for some other reason. So that's really important to note. Unfair dismissal, the compensation is capped at 6 months' pay, and it's up to that limit that we talked about before of 153 per annum. So half of that is around 76K. General protections, it's an uncapped compensation environment. So, and it can include compensation for pain and suffering, hurt or distress, whereas unfair dismissal is more about the lost wages. Unfair dismissal, there may be in order to reinstate. Similarly, general protections, there may be in order to reinstate the person to their job. Unfair dismissal, there's a time limit for any application, and that's 21 days. That 21-day limit also applies in general protections if a dismissal is involved. However, if the claim doesn't involve dismissal, we can lodge a claim up to 6 years after the protection was breached. So that really puts a lot of emphasis on the records we keep. So how can we be prepared? How can we make sure that we avoid some of those common pitfalls? So in order to dismiss, there needs to be a valid reason for dismissal. So we need to make sure that we follow a good process in determining what that reason is. Valid reason is not defined in the Fair Work Act. So we've looked to case law for interpretations, and we can provide a little bit more detail about that in direct discussions about a matter if we need to. But typically a valid reason deals with capacity or conduct. And you can see on the slide there what comes under that capacity heading. You may have heard of things like inherent requirements, so the physical or medical capacity of a person, certainly their performance is relevant, but there might be other inherent requirements like if someone loses a qualification that's important for the job, or their availability. For example, if they are imprisoned, they would be no longer able to meet the inherent requirement of coming to work. And conduct obviously covers misconduct or serious misconduct. With unfair dismissal and general protections involving dismissal, we need to make sure that we follow some key steps to avoid the risk of a claim. And they're set out on that slide there. Really important that we properly document our decision, we follow fair and objective processes, we're proportionate and timely in our decisions, and we're consistent. Very important to tell the employee why you're dismissing them, even if it's during the probation period, and follow the relevant processes. In terms of unfair dismissal, the Act is pretty good. It sets out for us the sort of things that will be taken into account by the Commission to determine whether or not the dismissal was harsh, unjust or unreasonable. So Section 387 of the Act gives us some clear guidance. And you can see there, they talk about valid reason, whether the person was notified of the reason, whether the person was given an opportunity to respond. And this is more than just asking their view, but taking it on board genuinely and considering it. This next slide, we bring up the question here of support person. There's no requirement for the person to have a support person offered to them, but we can't unreasonably refuse a support person. So that's something to bear in mind. In terms of unsatisfactory performance, we need to tell the person about that unsatisfactory performance and warn them about it and give them an understanding of what the consequences might be. The size of your business and the availability of HR expertise may affect the extent to which the Commission may give you a little bit of leeway, but please note it's not a get out of jail free card in terms of process. You must still follow good process. But this key element here at item H in italics there, any other matters that the Fair Work Commission considers relevant. And this is really where that harshness element comes in. The Commission might consider things like whether the person we're dismissing has dependents or whether they were in a remote location and whether re-employment might be difficult. All of those things need to be taken into account by you before you dismiss. Okay. So minimising the risk of an a general protections claim. Make sure your decisions are well reasoned and based on objective information. Be transparent with your employees about the reason or the rationale. In my experience, unless we tell someone why we're dismissing them from their employment, they'll come up with their own view about why that is. Keep notes and records, be fair in your approach, and ensure your communications are reasonable, whether that be verbal or written, and avoid any discriminatory or inappropriate basis for decisions. Okay. Just conscious of time, and so we'll move on fairly quickly here. Dealing with a claim, make sure you respond. Don't sit on your hands if you get notification from the Fair Work Commission that a claim's been made. Be factual and unemotional in your response. There might be things that are said in that claim that really annoy you. Just focus on the facts. Get advice and assistance if you feel like you're a little out of your comfort zone, and decide whether to attend the conciliation conference. You're not required, but typically it's a good idea. Decide whether you want representation. Think about what you're prepared to do or offer to resolve the matter, and then consider the pros and cons of not resolving the matter. Really think through whether it's a good idea to put an offer on the table. So, what do we want you to take away from today? Fair process. I've mentioned it a few times. It's so important. Avoid skipping any steps, even if time's a factor or it's inconvenient or it's a bit awkward or confronting to talk to your employees about issues, particularly around redundancy and those sorts of things, or conduct or performance. Be clear with employees about what the reasons are and the rationale for your decisions. Take a consistent approach. Treat each employee in a similar fashion. Doesn't mean we treat everyone the same, but with a similar approach and principles. Keep good records, plan your approach, and avoid mixing in different reasons for dismissal. Focus on what it's really about. Tell the employee that. I've mentioned that a few times. And know the limits of your expertise. If you are at the sort of outer edge of your expertise, then get advice. We always recommend that you check in with someone who does have that expertise. Okay, so to conclude, we have some resources on our website for non-members of the Chamber. Just go to victorianchamber.com.au and search for non-member IR advice. We have a contact number there and an email address you can contact us on for some IR advice. And we also have our previous webinars there on redundancy and the Small Business Fair Dismissal Code, as I mentioned. All right, we are right on time for finishing. I know I've gone through the content fairly quickly, so my apologies if you wanted some more detail on something. Look, thank you so much for attending, and we really appreciate you coming along and listening to us today. We have that advice number on our website, as I mentioned. Please make use of that if you have any further queries around unfair dismissal or general protections. Thanks so much.